Thank you so much for the invitation and for the opportunity to present my work here at your institute. I was telling Mohammed Reza yesterday when we met briefly that it's a very rare opportunity for me to speak with people who are familiar with Islamic law. Usually I find myself in situations where I'm speaking to a much broader audience, and usually they don't have much knowledge about Islamic law. And so it's a very rare and welcome opportunity for me to be able to speak with people who are familiar with the legal tradition and to get your thoughts and feedback. So I wanted to sort of begin giving a little sort of context to the broader project that I'm working on. So the talk that I'm giving today is coming from my book project, which is thankfully now towards the tail end. The book is really interested in this question of gender and the role that gender plays in the construction of the legal status of individuals in Islamic law, but I focus on the Hanafi fiqh in particular. And I kind of came to this topic largely from a very sort of vibrant body of scholarship that exists now in the academy that is trying to think about gender and the role of gender in Islamic law. And so as I kind of developed my own project, my dissertation, and then eventually the book, I realized that a lot of the questions that I think previous scholarship is asking really centers on this question of legal personhood. How does an individual acquire legal status? How do they become a legal person in the law? And what role does gender play in that? And so that's kind of where my book project is at now. And I became really interested in this question, and I think the larger body of scholarship that I'm referring to is really interested in this question of gender and the role that gender plays in Islamic law, because this question of women's status in Islamic law has been a burning issue in the past 100-odd years or so, and of course has a very long colonial history as well. From academic to confessional Muslim literature, I think there are two main arguments that have been made about women's status in Islamic law. One is that of the complementarity of gender. For those of you who have read sort of the more popular literature that is often available in English for in sort of communal and masjid spaces, this will sound familiar. This idea that men and women are complementary in their roles in society. So one is the complementarity of gender, and the other is this argument about women having a subordinated or disadvantaged status in Islamic law. So to demonstrate the first argument about complementarity, let me turn to the argument made by Jamal Badawi in his book, Gender Equity in Islam, Basic Principles. I use this as an example because of the expansive reach of this book and Jamal Badawi's argument in English-speaking Muslim communities around the globe. Published in 1995, his book, Gender Equity in Islam, is one of the most widely read English language texts on women's rights in Islam, written with the goal of clarifying misconceptions about the relations between men and women. Badawi argues against the term equality, which he argues is absolute equality in every aspect of comparison rather than overall equality. He prefers instead the term equity because it connotes justice and overall equality in rights and responsibilities assigned to both genders, allowing for variation in specific rights provided that there is overall balance and equality. While there might be particular aspects of the law that differentiate based on gender, Badawi's claim is that in the overall balance and assessment, the genders are equal in God's eyes. Gender differentiated laws for Badawi are justified through the argument that the roles of men and women in society are, quote, complementary and cooperative rather than competitive. Conversely, the scholar of Islam and gender, Layla Ahmed, argues that Islam continued and reinforced an increasingly patriarchal shift that was already underway due to the Greek, Roman, and Christian periods that preceded Islam. Ahmed's historical account, which has been highly influential in the field, and this book of hers, Women and Gender in Islam, which is a real classic in the sort of subfield of Islam and gender, just had I think it's a 30-year new edition that came out with a foreword by Keisha Ali. So it's a real it's a very, very influential piece in the field and gives a kind of meta-narrative, a historical meta-narrative about the role of gender in Islamic history and both in terms of social history, but also intellectual history. So it's been highly influential in the field, and it insisted on a tension between what she saw as the ethical impulse in Islam that was, quote, stubbornly egalitarian, and the developing orthodoxy that was not only hierarchical, but also decidedly patriarchal. Speaking of the development of the law in particular, she argued, quote, Orthodox Islam, on the contrary, gave paramountcy as it elaborated its understanding of Islam into laws to the practices and regulations Islam had enunciated, paying little heed in elaborating laws regarding women to the religion's ethical teachings, particularly its emphasis on the spiritual equality of women and men and its injunction to treat women fairly. As a result, the religion's emphasis on equality and equal justice to which women were entitled has left little trace on the law as developed in the Abbasid age. So this argument that she's making is specifically about the kind of early period in the development of Islamic law. For Ahmad, the status and autonomy of women was increasingly restricted as Islamic law developed and matured as a legal tradition. The question of women's status in Islamic law has been explored and nuanced by other gender scholars as well. In interrogating the legal construction of marriage and divorce, Keisha Ali has noted the relation between gender and slavery as categories of legal disability in Islamic law. These two categories, she argues, were not independent of one another, as marriage and enslavement were deeply connected in the juristic imagination of human relationships. Both enslaved people and women, she argues, were, quote, overlapping categories of legally inferior persons constructed against one another and in relation to one another, sometimes identified, sometimes distinguished. Despite the interconnectedness of these two categories of enslavement and gender, Ali argues that only gender is a permanent and enduring impairment to legal subjecthood in Islamic law. Judith Tucker has argued that women as legal subjects depend on, or the status of women as legal subjects depends on the area of the law that you're looking at. Thus, while women's agency in economic matters was largely similar to that of men, in other aspects of the law, they had more constraints on their agency. While women were recognized by the law as independent property owners, as a member of a family, a woman's agency was hampered by the interests of the family and a patriarchal society. Depending on the legal arena, Tucker argues, the tension between the full and impaired legal agency of the woman was resolved by allowing the interests of the patriarchal society to supersede. So for Tucker, where there is a conflict between the woman as a sort of full independent legal agent versus a constrained legal agency because the interests of the family come into play, there was preference given to the interests of the family and a kind of patriarchal society at large. Depending on the legal arena, So echoing Tucker's observation about the shifting legal agency of the woman, Marian Katz argues that while gender has a central role in juristic thought, quote, gender and its attendant legal implications are deeply modulated by reference to other markers of personal and social status. In early Islamic legal discourse, Katz argues, woman was not a homogeneous category, but was mediated by other factors. Jurists thus assumed that women of different ages and statuses would take on different legal rulings rather than a consistent ruling by virtue of them being women. The different accounts that I have presented so far all attempt to understand gender differential legal rulings and try to kind of, think about, okay, so how do we understand the fact that there are clearly gender differentiated legal rulings? What does that mean in terms of how women acquire legal status in Islamic law? These are kind of some of the general questions that I think are circulating amongst the different scholars that I've discussed so far. Gender scholars of Islamic law have recognized the important role played by gender in legal discourse, while also noting a tension between the central role of gender in relation to other social identities. In engaging with this body of scholarship, I see their object of inquiry as the question of legal personhood in Islamic law. In contributing to this ongoing conversation, I'm interested in exploring further this question about legal personhood to interrogate how individuals acquired legal personhood or legal status, and subsequently, how the rights and obligations of an individual were determined in Islamic law based on their legal status. So in this talk, I focus on several case studies related to marriage in early Hanafi law, and I look specifically at the 8th to 12th century, so kind of ending with Marghinani's Al-Hidayah, which is kind of a classic text in Hanafi legal, in the Hanafi legal school. So I look at the Hanafi legal school in particular during this early time period to argue that legal personhood in Islamic law was not tied to the gender of an individual. Neither man nor woman were legal persons in early Hanafi law. In my broader book project, I argue that legal personhood in Hanafi fiqh was constructed at the intersection of multiple social identities, gender being only one of the identities in this complex matrix of identities that defined a legal person. So the ones that I look at in my book in particular are gender, enslavement, and age, but there's really a myriad of different identities. It can be class and social status, lineage, just a number of different permutations of what kinds of identities were taken into consideration by jurists as they were thinking about the legal status of individuals. Thus, Hanafi jurists constructed the personhood of individuals not through a single category such as gender or enslavement or age, but instead at the intersection of different social identities. Focusing on legal personhood rather than gendered legal rulings allows us to see how these different social identities work together. In this talk, I'll focus instead, so one aspect of what I'm developing in the book is the kind of intersectional nature of legal personhood. But in this talk, I want to focus on what I call the relational and situational aspects of legal personhood, to argue that the particular construction of a legal person acquired meaning and power only in relation to other legal persons. The legal personhood of an individual was constructed through their social relations. Legal personhood was also not fixed, but constantly shifting as the life circumstances and situations of an individual shifted throughout their life. Rather than focusing on gender in Islamic law, I propose that we study the relations through which power was exercised. This approach would allow us to map the relations between different legal persons and how power functioned in each relation to establish a particular place in a very complex social hierarchy for different legal persons. Such an analysis is important if we seek to understand what factors shape an individual's legal status and subsequently their ability to claim rights and obligations. In order to do this, we cannot rely on a simple and static assessment of men as privileged and women as disadvantaged. This male-female binary fails to capture the complexity of how power and status function in legal discourse. There are, in fact, no simple predetermined categories through which we can predict a person's legal status or agency. So to better understand the relational and situational nature of legal personhood, let us consider the authority granted to the father and paternal grandfather to compel legal minors into marriage. While marriage in Islamic law is conceptualized as a contractual relationship between two parties, it did, of course, allow for both parties or one party or both parties to be legal minors. However, these legal minors did not have the legal agency to contract their own marriages, and so had to have the marriage contracted by a guardian. The question of who could serve as a guardian was one that Muslim jurists differed on, with the Hanafis allowing not only the father and paternal grandfather, but also other legal guardians to contract a minor's marriage. Now, the power granted to the guardians in contracting the marriage of minors was, of course, not just a matter of representing the minor's desire to enter into a marriage. The guardian carried, in fact, the power to compel the minor into marriage. For early Hanafi jurists, the minor's consent was of no legal consideration in contracting such a marriage. Now, the difference between the marriage contracted by the father and paternal grandfather versus the other legal guardians was manifested in the ability of the child to exit the marriage. In marriages contracted by a legal guardian, Hanafi jurists allowed the child to exercise a right of rescission or khiyar al-bulugh when they entered into legal majority. The marriage contracted by the father and paternal grandfather, on the other hand, was not subject to rescission. Instead, the minor child would have to wait until legal majority to exercise the right of divorce in the case of the minor groom, or to petition for divorce, or khul, in the case of the minor bride. The extensive powers granted to the father and paternal grandfather with regards to the marriage of minors was embedded in the juristic assumption that these two individuals were both of sound opinion, and therefore would make the decision that was most sound and in the interest of the child, and also had the child's best interest in mind. Despite the fact that historical records show that mothers routinely arranged marriages of their minor daughters, less so of minor sons, but sometimes also of minor sons, but what was much more prominent, at least in the Ottoman period that we know from social histories, is that it was fairly routine for mothers to contract marriages of their minor daughters. Hanafi jurists assumed that the mother does have the child's best interest in mind, but could not be relied upon to make sound judgments in establishing new kinship connections. The jurists granted such expansive authority to the father and paternal grandfather that even if they made seemingly unsuitable or incompatible matches, the marriages they contracted could not be voided. Now, given this expansive power and authority granted to only the father and paternal grandfather, who are both sexed male, we might be tempted to argue that such authority was granted to them by virtue of their maleness. I would argue, however, that this authority and a power of compulsion cannot be understood as simply the effect of maleness. Instead, we must understand it as the effect of the father-child relationship. Certainly, if we look at the juristic determination to grant the paternal grandfather greater authority than the mother in contracting these marriages, it would seem that it is a shared maleness between the father and the paternal grandfather that confers this authority. I point to the relational aspect of this right of compulsion, the father-child relation, not to downplay the gendered nature of authority, that's certainly at play there, but to urge us to consider that this authority is neither essential to individuals who are sexed male, nor is it acquired by all men. If we analyze this authority given to the father and paternal grandfather as one granted to legal persons who are sexed male, then there are several discrepancies that we'd have to account for. The most obvious of these is the fact that the minor son is also subject to compulsion in marriage. While the marriage of minor sons was perhaps less prevalent as a social practice than the marriage of minor daughters, and Carolyn Baugh talks about this in her book, that even in legal discourse over time, in the post-classical period, you see a lot less juristic discussion of the marriage of minor sons than of minor daughters, which seems to indicate that perhaps it had fallen out of practice. But nonetheless, sort of, as a matter of legal principle, the minor son's maleness did not grant him the self-determination that would protect him from compulsion. Similarly, the law did not recognize all fathers as patriarchs. Enslaved people, for example, could not exercise authority over others in society, and thus could not serve as guardians. As an enslaved person, then, the enslaved father was neither a patriarch of a family, nor did he carry the legal capacity to exercise authority over his children. Hanafi jurists only recognized free fathers as carrying the power and authority of a patriarch. The free father was not only seen as holding authority over his children, but also had a vested interest in the family and controlling the kinship relations that were established through marriage. As the father of a son, the paternal grandfather also held this position of patriarch and was equally vested in the decisions regarding the family. The paternalistic ethic of care that governed the father-child relationship assumed that paternal instincts would prevent the father and paternal grandfather from making decisions that would harm the child's welfare. The child, however, is also a member of the family, and as such, the marital decisions that were of benefit to the family were also seen to be in the best interest of the child. So there's a kind of mutual understanding of best interest and benefit that is working here, rather than one that centers on an individual's interest and an individual's right in tension with that of the family and community, which I think is much more characteristic of liberal modes of thinking. It is for this reason that unlike the legal guardian whose marriage decisions could be scrutinized, Hanafi jurists did not make a similar provision for the marital decisions of the father and paternal grandfather. The father and paternal grandfather's authority and power is thus only acquired when a particular relation is established. That is, once a man is married and becomes a father, or subsequently when his own sons have children. This paternal authority is also curtailed to the relationship, to this father-child relationship alone, and does not extend to all the relations that an individual is embedded in. What I mean by this is that the free father as a patriarch exercises this authority only in relation to particular legal subjects, that is, minor children. While he also held authority as a husband, potentially also as an enslaver, those relations might share some aspects of paternal authority and yet differ significantly in other ways. While we might be tempted to see children, wives, and enslaved people as all sort of one big category of dependence, each one of these was a unique form of dependency that constructed unique legal personhoods, creating for different modes of legal agency and power relations. The legal personhood of the father and the minor child then are relational and relationally and mutually constructed, acquiring meaning only in relation to one another. Thus, a change in the father and minor child relation to the father adult child relation also shifted the legal agency ascribed to both. As a free child approached puberty, they entered into a liminal stage that the Hanafi jurists defined as prepubescence or murahaqa. In this liminal stage, the free child began to acquire greater rights of self-determination. Thus, they could contract their own marriage, with the marriage being suspended until the guardian expressed their consent. Hanafi jurists also allowed for a free prepubescent child to begin engaging in commercial transactions under the supervision of their guardian so that they might acquire experience in handling financial matters. In this liminal stage, the free child was being socialized to enter into the world of free adults. Upon reaching legal majority, the free adult child, whether male or female, could no longer be compelled into marriage. As a free child came into legal majority, they entered into the social world of free adults and thus acquired greater legal agency. In a world where the ability to procreate and fatherhood were markers of increased social status, puberty marked a free minor boy's entrance into the social world as a potential patriarch. As the 12th century Hanafi jurist Ala ad-Din al-Kasani argued, nocturnal emissions marks the boy's ability to procreate, which allows him to move from the domain of children into that of fathers. For a free minor girl as well, puberty marked the possibility of marriage and procreation. If she was already married, consummation and moving into the marital home marked a shift in her legal personhood, granting her greater social status and autonomy. So for girls and for adult women, it's sort of not just a matter of entering into legal majority, but also sexual status that are sort of both at play in allowing women to acquire greater self-determination and autonomy. The right of compulsion in marriage granted to the father and paternal grandfather demonstrates this relational nature of legal personhood. This power and authority granted to them was not by virtue of their maleness alone, but instead came into effect only through their relation to their minor children. This position was also not granted to all fathers, but only free fathers who could take on this position of a patriarch. The legal inability of the minor to exercise self-determination was also not a condition of every relation in the minor's child. So this is not a kind of identity that they would carry in every aspect of who they are, but was instead confined to the father and paternal grandfather, and in their absence to other legal guardians. So that kind of constraint in their agency, right, was confined to a particular relation, which is that to the guardian. As the minor reached legal majority, a change was also affected in the relation between the father and the child. The relational nature of legal personhood also meant that individuals occupied multiple legal personhoods at the same time, depending on the different relations in which they were embedded. For an individual to occupy multiple legal personhoods meant that the intersectional configuration of social identities that shaped an individual's legal personhood was not an essential aspect of a person, but instead dynamic and constantly shifting. So, being a a woman, for example, as an identity that you carry in every aspect of your life, and that it has a static meaning is not something that I think is happening in Islamic law, or at least in Hanafi fiqh. As intersectionality scholar Patricia Hill Collins argues, scholarship on intersectionality has helped us to recognize that individual identities are not only intersecting, but they're also performative, changing our conception of identity from something that one has to something that one does. Identity then is not a fixed essence, but instead something that an individual carries with them from one situation or one social context to the next. Stuart Hall argues that, quote, identity is not a set of fixed attributes, the unchanging essence of the inner self, but a constantly shifting process of positioning. In fact, identity is always a never completed process of becoming, a process of shifting identifications rather than a singular, complete, finished state of being. Theorizations of identity as performative, positional, and a continual process of becoming are helpful in grasping what I'm calling this relational nature of legal personhood in early Hanafi law. First, it points us to the fact that identity is not simply a personal matter, right? It's not something that you as an individual decide to take on, but is shaped by social structures, and in our case here, the legal system. These social structures not only create identities as a vehicle through which power relations are exercised, but also provide the conditions that result in the internalization of these identities by the individual. Secondly, it demonstrates that identity is shaped by multiple factors and shifts from one social context to the next. This allows us to see that identity is not essential to the individual, but instead something that is acquired and also differentially performed based on shifting context and social relations. So to demonstrate this point, let us turn to the free adult wife as a particular form of legal personhood. As a free individual, the free adult woman had ownership over her own sexual commodity, particularly, I'm talking here in the context of Hanafi law that would allow her to contract her own marriage, and had the self-determination that allowed her to contract her own marriage. Neither the free minor girl nor the enslaved adult woman had the legal capacity to exercise such self-determination. Both the free minor girl and the enslaved adult woman could be compelled into marriage, and neither could exit that marriage until emancipation in the case of the enslaved wife, or legal majority in the case of the minor bride. The free adult woman, on the other hand, acquired self-determination through both freedom and legal majority. And now, of course, for the Hanafis, there's constraints to this in terms of rules around kifa'a or compatibility, and there are a number of different considerations in deciding whether an individual that a woman has chosen to marry would be considered compatible, and if not, then her family can challenge her marital decision. Once she married, however, the free adult woman acquired the legal personhood of a wife, a relation that required her to take on a subordinate position in relation to the husband, to obey him, and relinquish her sexual autonomy and mobility. The free adult wife as a legal person, however, was only constrained in legal agency and autonomy in relation to the husband. She did not carry the legal personhood of a free adult wife in all of her relations. As a free adult woman, for example, she had ownership rights and as such could be an enslaver if she had the financial means to do so. In her relation as a female enslaver, then, she exercised power and authority over the people she enslaved. As Keisha Ali has mentioned, femaleness certainly constrained the position of a female enslaver. She could not, for example, make sexual use of enslaved men the way that the way that a man, for example, could take on an enslaved woman as a concubine. A woman would not be able to do the same. Where early sources mention instances of female enslavers interpreting scripture to claim such a right, there was no hesitance in intervening in a manner that violated her ownership rights. While femaleness was certainly at play in the position given to the female enslaver, we should be hesitant to read this femaleness as a shared identity across the female enslaver and the enslaved woman. So what I mean by that is that, there's a tendency to kind of see both the female enslaver and the enslaved woman as both women, and therefore having some kind of shared disadvantage in society. Like male enslavers, female enslavers were also oriented towards enslavement as a relation of property and were invested in enslavement as both an economic advantage as well as a means for acquiring authority and social status. By virtue of the enslaver-enslaved relation, the female enslaver exercised many of the same rights over enslaved people as male enslavers. While she might not have been permitted to make sexual use herself of enslaved men, she still held ownership over the sexual capacities of both enslaved men and women, and she could compel them into marriage, and any children born through the women she enslaved were her property. As both a wife and a female enslaver, then, a free adult woman could occupy different legal personhoods at the same time. Each one of these legal personhoods was relational and situational, that is, it was acquired in a particular relation and was tied to that specific situation. The constrained legal agency of a free wife was tied to her relation to the husband. As a female enslaver, she occupied a very different legal capacity, exercising power and authority over others, which in turn granted her admission into the sort of elites and and sort of financially privileged in society, or a certain kind of a class and social status. Legal personhood in early Hanafi law did not reflect some essential and unchanging nature of the individual, but was instead dynamic and shifting. It was acquired by the individual based on their positioning in a particular relation and was shaped by the context of that relation. As individuals exist always in multiple relations, this meant that an individual acquired multiple legal personhoods at the same time. The resultant effect of this was that no single legal capacity or legal agency defined an individual at all times or in each relation. So we can't find, if we sort of go in thinking, okay, how does gender constrain the legal status of women? The assumption is that gender acts alone and that women are a singular category, and that you will see that kind of traveling in every aspect of the law, right? That kind of essential sort of identity as a disadvantage will travel in every aspect of the law. And what I'm arguing here is that, that's not what we see in Hanafi law, in early Hanafi law. The constraint that an individual carried in one relation was not carried by them in all relations. The feminist legal theorist Nigeri Nafin argues that modern legal systems, particularly those emerging from liberal traditions, present themselves as impartial, treating all individuals equally regardless of their particularities. This legal person is ungendered, imagined as sovereign, self-legislating, and autonomous, unencumbered by relations of dependence. The modern legal person is seen to derive their rights and duties from personally chosen contracts. This frees them from customs and traditions, as well as familial relations and community obligations that are not of their choosing. This idea of the modern legal person is also understood to be universal, an abstraction that can be applied equally to all individuals. Feminist legal theorists have, of course, critiqued this triumphalist account of legal personhood, arguing that women have never been allowed to be sovereign, autonomous, and rational subjects. They argue that the abstracted notion of the modern legal person is in fact based on an imagination of a social order in which only particular types of individuals can flourish. The legal person imagined by the law, Nafin argues, is a middle-class white man who is able to thrive in the competitive market. Such a man is able-bodied, autonomous, rational, educated, moneyed, competitive, and self-interested. Now, legal personhood, in contrast to that, legal personhood in early Hanafi law was neither abstracted nor centered the individual as a legal person outside of their social, familial, and communal ties. In this legal world, personhood was constructed as both relational and situational. By relational and situational, I intend two things. A, that legal personhood was established based on the relation in question and was mutually constituted by those relations. An individual thus acquired legal personhood based on their social relations and their place in a very complex social hierarchy or a very complex social order. And B, legal personhood was dependent on context and situation. As situations and relations changed, so did the individual's legal personhood. The resultant effect of this was that legal personhood was not fixed but dynamic and constantly shifting. The legal person in early Hanafi law was not an abstracted individual, but instead constructed through the social relations in which the individual was embedded. The legal person imagined by the law or by Hanafi law was not a self-determining and autonomous individual. Autonomy existed instead on a spectrum, with individuals acquiring greater or lesser autonomy depending on the particular relation in question. No individual, however, was seen as fully autonomous in the sense of being freed from their social relations or from obligations to exist in relations except through their own personal choice. Social relations were understood as a fundamental aspect of human and social existence. The relational and situational nature of legal personhood meant that the authority and privilege, or conversely, the legal incapacities and subordination ascribed to the individual, was not essential to them, but instead pertained to that particular relation alone. The legal identity of an individual in early Hanafi law, then, was not fixed in status, but instead continuously in process. Thank you.